Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye.
Clerk will report. Gentlelady from Wyoming.
Yes. Ms. Hageman votes yes. 14-12, 14-12. Mr. Chairman, there are 14 ayes and 12 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 1605, the Separation of Powers Restoration Act of 2025 for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1605.
Without objection, the bill will be considered as read and open for amendment at any point. The chair recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Mr. Chairman. The Constitution deliberately separates the powers of the federal government in a system of checks and balances. Article 1, Section 1 vests all legislative power in Congress, while executive power belongs to the president and the judicial power rests with the courts. This foundational structure ensures that no single branch dominates the other, safeguarding individual liberty from government overreach. But for decades, the executive branch has taken legislative power by issuing regulations that carry the force of law. In 1984, the Supreme Court ruled in Chevron that courts must defer to an agency's interpretation of an ambiguous statute, rather than exercising independent judgment to determine what Congress actually meant. The deference allowed unelected bureaucrats to wield immense legislative and judicial power and issue sweeping regulations with little accountability. In 2023 alone, unelected bureaucrats finalized over 3,000 rules. By contrast, during the same period, Congress passed less than 70 laws. This means the executive branch agencies impose more than 44 times as many mandates as the actual legislators. The consolidation of power within the executive branch directly contradicts our constitutional framework and harms American liberty. It is certainly not what our founders intended. And the regulatory state is not just oppressive, it's costly. According to the Competitive Enterprise Institute, the total annual cost of the federal regulation is now $2.1 trillion, equivalent to over 7.5% of U.S. GDP. If members of this chamber impose that kind of cost on taxpayers each year, we'd be voted out of office. Fortunately, the Supreme Court has finally restored the judiciary's constitutional role in interpreting the law. In a 2024 case known as Loper-Bright, the court explicitly overturned Chevron. The Supreme Court held that under the Administrative Procedure Act, courts must exercise independent judgment while reviewing whether an agency has acted within its statutory authority. As Chief Justice Roberts, quoting Alexander Hamilton's Federalist No. 78, wrote in the majority opinion, the framers, quote, envisioned that the final interpretation of the laws would be proper and peculiar province of the courts. He went on to note that the Administrative Procedure Act, quote, incorporates a traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions, end quote. In other words, the Supreme Court has now recognized what we in Congress have long understood. Chevron was an abdication of judicial responsibility that allowed agencies to run roughshod over both the Constitution and the will of the people's representatives. But while Loper-Bright is a major step in the right direction, it does not resolve all questions of judicial deference. The court left open the question of whether other deference doctrines should be overturned. And courts may very well find ways to invent new deferences doctrines if we do not stop them from doing so. That is why it remains imperative that Congress act to solidify the judiciary's duty to review agency action and ensure that the executive branch cannot continue to legislate outside clear congressional direction. That is why we must pass H.R. 1605. Separation of Powers Restoration Act would formally codify the Supreme Court's decision in Loper Bright and invalidate any other precedents that require courts to defer to agency positions. This will ensure that courts independently consider what Congress has said through its statutes rather than putting a thumb on the scale in favor of the federal agencies. By requiring courts to apply de novo review, this legislation would ensure that judges exercise their constitutional duty to interpret the law independently, rather than deferring to the very agencies whose authority they are supposed to scrutinize. I urge my colleagues to support this critical legislation and restore the balance of the power demanded by our Constitution, and I yield back.
Gentleman yields back. Ranking member is now recognized for an opening statement.
Thank you very much, Mr. Chairman. Administrative rules take on different political meanings at different points in history, depending on who's in office, who has more power in the courts. And the history of the Chevron in Loper Bright is fascinating, especially in light of Mr. Fitzgerald's very interesting remarks there. I'm old enough now to remember when Chevron was decided. I was in law school at the time in 1984. And at that point, when it came down, Chevron was considered the conservatives' doctrine. It's what Ronald Reagan wanted. It's what the conservative judges on the Rehnquist court and the Berger court had been fighting for. The liberals basically were saying we've got great regulations and rules that have been put in since the Great Society on clean air and clean water, and we don't need a new doctrine. But the conservatives on the court introduced the Chevron doctrine because the liberals wanted to stick with a particular regulation which determined that the word point in pollution had a fixed meaning, whereas the conservatives were saying, no, the EPA, now under Reagan appointees' control, can rearrange the meaning of the word point and have point applied to the entire factory rather than one particular point of discharge. So it was the conservatives then who had advocated the Chevron doctrine and embraced it and were cheering the development of this great new flexibility notion, because it allowed the Reagan appointees at the agencies and commissions to reverse rulings that had been in place for a long time. All the liberal environmental and labor lawyers were going to court saying, no, this is what the statute has meant or the way it's been interpreted for 20, 30 years. But now the conservative court in the hands of the Chevron doctrine said, no, it should be, it's a flexible test, and as long, if there's inscrutability or indeterminacy in the language, then we're going to defer to the agency's own interpretation. All right, so I was always very skeptical of the Chevron notion for the reason that the Supreme Court enunciated in the Loper Bright decision, which is that it's up to the courts to say what the law is. And that goes back to Marbury v. Madison in 1803. It's emphatically the province and the duty of the judicial department to say what the law is. And the agency's role is to be part of the implementation process, but any final authoritative construction of the meaning of the statutory language must rest with the judiciary. So times change, of course. So now we're in a period where the conservatives hate the Chevron doctrine, and the liberals who had originally denounced it now, have been standing with it. All of which goes to show that a neutral rule can take on a very different meaning depending on who's occupying this or that office. I was about to call you, Mr. Chairman, to say, shouldn't we go ahead and say what the vote is? Everybody has voted. We were waiting for more people. But the rule is it's up to the chair to decide when to close the balloting. That's going to help you guys sometimes when you're sitting in that chair. And maybe if I ever get to sit in that chair, it would help us, all right? So you don't know which way an administrative rule is going to cut. Given that, I've always felt you should try to decide it on the merits as much as possible, what you think it is. And I've always felt that the position just enunciated by the Supreme Court is the right decision in terms of interpreting what the law is. So I like the Loper-Bright decision, and I like a lot of what's in this bill. However, I've been working with the chairman to see if we can come around. The part of the bill that I don't like deals with the statute of limitations. So the compromise that we came close to, but in the final analysis it didn't work, it would have scrambled certainly partisan and doctrinal lines. The compromise would have codified the new post-Chevron world, making clear that courts should review agency actions de novo and exercise their own independent judgment in deciding whether an agency has in fact acted within statutory authority. It also would have enshrined certain guardrails, explicitly instructing courts to continue applying stare decisis, as well as continuing to give respect to executive branch interpretations, particularly when based on specialized experience. These are the so-called Skidmore factors. But what's more, the compromise would have overturned the Supreme Court's ruling in the Corner Post decision, which broke with decades of precedent and would have made clear that facial challenges to rules and agency actions must be made within 8 years of the promulgation of the rule. This language, built on my colleague Mr. Nadler's Corner Post Reversal Act, would have avoided the free-for-all that exists when federal rules are in a perpetual state of limbo, where litigants can challenge them even if they've been in place for 20 years or 30 years or 40 years. There's no stability for anybody in that, and that just undermines rule of law values. So, unfortunately, at the 11th hour, I believe some of our GOP colleagues walked away from what I was hoping would be a big compromise that we could all live with. In other words, Loper-Bright, which is the law of the land right now, would be codified, but we would not allow rules to be perpetually challenged, which would introduce a lot of instability into the law. So that bipartisan deal collapsed, my preference would have been today to vote on that bill that we were discussing, to the extent that my colleagues are intent on putting up this other version of the bill, which allows for perpetual challenge, I cannot go along with that, and I would have to vote against that. But if it passes the committee, I do hope, Mr. Chairman, that you know I'm sincere about this. I hope we can continue to work together to improve the bill and find real common ground as it moves through the legislative process. It's a good opportunity for us to act in the true spirit of bipartisan compromise and common sense. And I think it would demonstrably improve the bill because, yeah, you can always bring a constitutional challenge, but I don't think an arbitrary, capricious challenge, an ultra-virus challenge should last forever. I don't think people should be bringing those 20 or 30 or 40 years later. So I hope we can continue to work on it, but otherwise I'm not quite there yet. And thank you for your patience, and I go back to you.
Gentleman yields back. Chair recognizes the gentleman from Wisconsin to offer an amendment in the nature of substitute.
Thank you, Mr. Chairman. I do have an amendment at the desk.
Clerk will report.
Amendment in the nature of a substitute to H.R.
Objection to the amendment in the nature of substitute will be considered as read and shall be considered as base text for the purpose of amendment. Chair recognizes the gentleman from Wisconsin to explain the amendment.
Yeah, this amendment adds interpretive rules, general statements of policy, and all other agency guidance documents to the scope of the bill. These were included in the version of the bill that passed the House last Congress, and I would urge support for this amendment, and I yield back.
Gentleman yields back. The chair would claim some time for a question to the sponsor of the bill. Is there anything in the current legislation that talks about statute of limitations?
Chairman, there is not, which when the ranking member discussed this, and I think the negotiations that were happening behind the scenes, that would lend me to believe why not pass this bill today, and then if we want to come back and talk about a statute of limitations later, that seems like it might be more productive.
Yeah. And that's where I'm inclined to go, and we have had discussions with the ranking member and our staff and their staff, and we'll continue to do that, see if we can find some common ground. But there's nothing in this legislation that addresses or deals with the statute of limitations. Who seeks recognition? The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I moved to strike the last word. I think I was recognized. I just want to agree with our brilliant ranking member that he's pointing out the contradictions that occur when one party tries to move and make a situation work for them despite what the merits of the situation might be. And I think that that is a very real point. I do think that this particular bill has tremendous problems. I'm going to vote no on it. I think that if we are to think about the central issue here, it is the question of where expertise should lie. And at the end of the day, I think part of the reason that this administration has been focusing so intently on destroying agency authority, getting rid of expertise within the agencies, and replacing that, either completely eliminating a department illegally that was established by Congress, or eliminating expertise that has been critical to making these decisions over these years, is because they know that those agencies are actually accountable to Congress. So when we write legislation and we articulate what we intend to be done, it is very difficult, I think, particularly in technical areas that cross a number of different sectors, for us to give full and complete determination of exactly what that looks like. And so we have seen Chevron deference in the 40 years that it's been the law of the land require courts to give expert agencies the chance first to implement ambiguous laws, and that has led to an enactment of many important policies. And, you know, I'll just name a few: how to limit greenhouse gas emissions under the Clean Air Act, which drugs and medical devices should be covered by Medicare and Medicaid, or how labor unions across the country hold free and fair elections without the interference of greedy employers. None of those things would have been possible without Chevron. And you could probably say that of the decade before as well. So I don't dispute that point at all. But I do think the central question is, who decides these important policies? And when Congress makes a determination, when we enact a law, that we do delegate some responsibility to the agencies. And I think that judges have another very particular set of expertise, a very particular range of expertise that they offer, which is critically important. And they, before the Supreme Court ruled recently, they had sort of the end analysis of whether something was appropriate or not, but they didn't have to have the detailed technical expertise that we have relied on agencies to have. And so I think it is very important that experts decide on subject matter as much as possible, and that they are accountable to Congress. Because if you take that away, then you have a judiciary who is not accountable to Congress, and they might interpret exactly what they think the law should be based on a whole range of things that we may or may not agree with. And I think we've got to be very careful about codifying the Supreme Court's, it is the law of the land, I'm not arguing with that, but codifying it in hopes that perhaps this returns us to a period of the 40 years prior to Chevron deference, because I think so many things have changed. And I also think at the end of the day, we should be looking at this on the merits of the situation, not by whether the current administration is taking away the ability of agencies to do the things that they are supposed to do, because frankly, an administration that wants to destroy the agencies and the separation of powers between Congress and the executive branch, and seeks to essentially eliminate the authorities of Congress under Article 1, is also the same administration that might do that with the judiciary. For example, might ignore the unanimous Supreme Court decision to facilitate the return of Kilmar Abrego Garcia. I mean, there's all kinds of things that can be done to eliminate the separation of powers, and I think we should be looking at where should expertise lie. In my mind, anyway, that is the central question of this point, and that is why I wrote the Stop Corporate Capture bill, because my bill offers a comprehensive blueprint for the kind of modern, people-centered regulatory system that the public expects and deserves. And I think it would level the playing field for all Americans to have their voices heard on these critical regulatory decisions. It would promote scientific integrity, public accountability. It would codify Chevron deference, and it would restore our government's ability to deliver results. So that is still where I am. And I think if we're going to have this conversation, I just hope that we can do it as a group and not just change our
The gentlelady's
position.
time has expired.
I yield back.
Is there further discussion?
I move to strike the,
Mr. Onder.
Yeah, thank you, Mr. Chairman. Well, I really commend Mr. Fitzgerald for bringing forth this bill. I really love this bill. In fact, I like it so much that on the campaign trail last year, I talked repeatedly about codifying Loper-Bright and for once and for all making it clear in statute that the Chevron doctrine is no longer the law of the land. You know, the 4 decades since Chevron have witnessed an enormous growth in the power of the regulatory state and the size and cost of the regulatory state. Unaccountable bureaucrats, so-called experts, have subverted, in many cases, the will of the people and vastly expanded the power of the executive branch beyond what was anticipated by either our founders or by the drafters of the statute that those unaccountable bureaucrats allegedly were interpreting. Not only that, there's been an enormous power grab by these bureaucrats of the Article I powers of Congress, of the power of judicial review that is so clear in our Constitution, and finally, the power of individual citizens and businesses, litigants, to go to court to defend their individual and property rights against the aggressive and inappropriate use of power by executive branch bureaucrats. So why do we still need this bill? We need this bill, as Representative Fitzgerald said, to make sure that other doctrines, other deference doctrines, don't continue to be abused by bureaucrats. And number 2, we do not know what the composition of the court will be. So it is time for Congress to make very clear that the Chevron doctrine no longer stands and that so-called experts cannot rule our lives and the lives of businesses throughout this country. I thank the representative for this bill.
Gentleman yields back.
I yield
Is there
back.
further discussion? Mr. Nadler.
thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized.
Mr. Chairman, when I saw that we were marking up a bill called the Separation of Powers Restoration Act, I wondered if that meant that our Republican colleagues were finally ready to assert congressional authority and stand up to President Trump's unprecedented power grabs. On issue after issue, the Trump administration has thumbed its nose at Congress and claimed practically unlimited power for the executive branch. And what has been the response of my Republican colleagues? Crickets. So I was heartened to see that we might consider a bill to finally reassert appropriate checks and balances and to restore the separation of powers that our Constitution has enshrined. But sadly, this bill would do nothing to respond to the crisis at hand. Instead, it would double down on the Supreme Court decision in Loper-Bright, enabling courts to ignore agency expertise and make it easier to overturn life-saving regulations. I appreciate Ranking Member Raskin's efforts to improve the bill, in particular by adding language from my legislation to overturn the Supreme Court's recent decision in Corner Post, which eliminated the statute of limitations on challenging regulations under the Administrative Procedure Act. I am disappointed that the majority would not agree to his offers. Without that language, this bill would allow for wholesale rollbacks of standing agency rules going back decades. This could lead to chaos, endless litigation, uncertainty for businesses, and ultimately a government that cannot effectively govern. Therefore, unless that language is placed in the bill at some point in the legislative process, it hasn't been yet, I must oppose the bill. I yield back.
Could the gentleman yield? Oh, I'm sorry.
Oh, I'll yield.
Yeah, thank you. I wanted to respond to the last 2 comments and really the last 3. The whole point that the gentlelady from Washington made so powerfully about expertise. The problem I think is that expertise is in the eye of the beholder. I was going to ask the the gentleman who I think had to leave the room, he was saying, we should not be deferring to so-called experts. We should be enforcing the law as it is. So here's an interesting case that has come up in this new administration. And this is what I mean about how, there's a do-si-do going on. The roles switch completely. So the new Secretary of HHS, Secretary Kennedy, has said that the Department of Health and Human Services is not bound by the Administrative Procedures Act and is not going to follow it. Now, I suppose he would be the expert here. It's hard to identify his particular views with expertise, but in any event, he's saying as the Secretary of HHS, he's not going to be bound by the Administrative Procedure Act. Well, that's an outrageous violation of the rule of law. I think we want a court to be reviewing that. And as the various cabinet members decide they want to go off on their own direction and disown the whole body of regulations that have grown up in their particular agency or department, I think that we are going to want the courts enforcing that. Now, unfortunately, President Trump himself has also said he's not bound by the Administrative Procedures Act. And I hope that all of us would agree that can't be right, because the Administrative Procedures Act is the way that we actually conduct the promulgation of regulations through the notice and comment period and through, all of the steps that are built in there. So, my problem, my only hang up with this bill is the Supreme Court's decision in the Corner Post case determined that the statute of limitations runs from the point of alleged harm to a litigant rather than from the point at which the regulation was adopted. And I think that doesn't give anybody, especially the business community, which has complained about it, but also workers, environmental groups, it doesn't give anybody any predictability or order in the system. So personally, I would like to add what's in this bill with a language that that gets us away from that corner post approach and makes clear that we can build a lot more definiteness into the system. I thank the gentleman for yielding.
I yield back.
Gentleman goes back. Is there further discussion?
I move to strike the last word.
Gentleman's recognized under the 5-minute rule.
Thank you. I noticed my colleague on the other side made the point that this bill is able to attack a problem of bureaucrats usurping Article I power. And I took note of it because I don't hear my Republican colleagues talking about Article I power very much anymore, as Donald Trump and this administration have completely usurped all of Congress's power, the power of the purse, the power to use executive orders to overrule legislation, to cancel effectively to agencies that Congress created. But somehow you found Article I power when it comes to, quote, unelected bureaucrats. Now, I was a clerk for a district court judge in San Francisco who had a lot of patent cases. And really, they're so complicated and so technical that he might as well have thrown a dart at a dartboard to see which way it would come out. It was just beyond his expertise, which he would have readily admitted. And so the notion that judges somehow have more expertise about the intricacies of implementing complex laws, whether administrative laws, especially whether they be environmental or financial or in some other ways, is absurd on its face. And it may be politically expedient for my Republican colleagues to want to put this power in the court's hands, but it will make our system much, much less effective. And I'm frankly sick and tired of hearing the term unelected bureaucrat as if the patriotic men and women of our federal government who are working anonymously for the United States to execute our laws, to protect our borders, to engage in diplomacy abroad are somehow, because they're not elected to office, any less competent or expert than somebody who, I guess, who wins an election is preposterous. But I would note that if your concern is Article 1 power, I might encourage you all to speak up against this Department of Justice charging with criminal charges one of your colleagues for doing her job, her constitutional mandated job. Now, I know many of you think you take an oath to Donald Trump, but in reality, the oath is to the Constitution. And you ought to be very, very careful about continuing to stay quiet as this president ravages and destroys our democracy and completely undermines and devastates your Article 1 power. So if you're going to find God and recognize that there's Article 1 power when it relates to administrative law, I hope you will also find Article 1 power to stand up to a rogue authoritarian administration rather than continuing to sit quietly as your own power is taken away and your own colleagues are being arrested for what is so obviously a politicized, trumped-up, bogus charge. And
Will the gentleman just yield for a friendly but
yes,
but probing question? I hope. Okay. So this is on the point of expertise. You have a lot of courtroom experience. Say there's a case about whether someone was driving DUI. There's no doubt that the chemist who knows about body chemistry and alcohol is going to know more than members of the jury. But we still leave the ultimate determination to the jury to use their common sense, but they're allowed to take in all of the expert testimony. So why is it that we would say we want somebody who has expertise to be making a decision on an ambiguous or inscrutable part of a statute rather than a court whose job it is to interpret the meaning of the law?
well, it's clear the courts have to have a role, and I don't think any of us are saying that the courts shouldn't have a role, and that's why I wish we would work in a more bipartisan way to rewrite administrative law after Chevron, because this is a very, very important issue that will have many, many follow-on effects. But for a judge or a jury or anyone who's not a scientific expert or a specific expert in a field to learn an entire field without the benefit of those who are experts fundamentally undermines the efficacy of our laws and the implementation of our laws. So why we would shun expertise is beyond me. And I yield back.
Gentleman yields back. Question is on a, Ranking Member, one time.
Yeah, move to strike the last word.
Gentleman is recognized.
Just to complete that point, Mr. Chairman, and I appreciate it. Look, this is in defense of the Loper-Bright decision, okay? Loper-Bright did not negate or nullify or demolish the role of administrative expertise in the agencies or departments. All it said, in fact, it reaffirmed that if there really is a clear delegation from Congress to an agency, the agency can do it. But where it's not clear, then as a matter of law, Loper-Bright says the courts have got to be determining that rather than the unelected bureaucrat, whether that unelected bureaucrat is Joe Califano or Robert F. Kennedy Jr. That is, whoever is there doesn't get to define what the law means, but they do get to execute the meaning of the statute. So that's why, to me, the Loper-Bright approach seems compelling, and we should work with it. But I just hope that my Republican colleagues, who I'm siding with here, understand the import of the position they're taking. First of all, the last bill that we just discussed is utterly ridiculous from the standpoint of Loper-Bright. It vests all power in an unelected bureaucrat. The idea was you have the regulatory notice and comment period, and then everybody, for some reason, goes to the general counsel of the Small Business Administration, and that person gets to decide, as if that person is more expert than all the other administrative experts and better at interpreting the law than the courts. So that bill is precisely what I think is being condemned by Loper-Bright. But I also want my colleagues just to understand what's going to be happening over the next 3.5 years is that people like Secretary Kennedy are going to be coming out with their rules and their regulations, and the courts are not going to be deferring to them, and they shouldn't be deferring to them if they operate in a realm of ambiguity within the statute. And so I just want everybody to be clear, you're committing yourselves with this vote to that position, that the courts should not be deferring to, Attorney General Bondi with respect to a DOJ regulation, or Secretary Kennedy with respect to an HHS regulation. It's going to be up to the courts. And I know a lot of you have been talking about impeaching federal judges because you don't like what they've been doing, and you haven't really bothered to say what's wrong with the legal analysis that is exercising you, but you still want them impeached. And you're moving in a very different direction now, and it's the direction I believe in, which is that the courts are the place where we go to find out what the law means. Like Marbury versus Madison said in 1803, it's emphatically the province and the duty of the judicial department to say what the law is. So thank you, Mr. Chairman. I just wanted to add that point.
I thank the ranking member. The gentlelady from Wyoming is recognized.
Well, I think we need to understand what Loper-Bright did and what Chevron did, and we can do it by using some real-time examples. What the point of Chevron was if there was an alleged ambiguity in a statutory, in a bill, then they would defer to the agency's interpretation of what that statute meant, rather than going through the process of determining what the law is, which had been basically within their purview up until 1984. And so we got such incredible absurdities. For example, let's use the Clean Water Act. The Clean Water Act gives to the EPA jurisdiction over navigable waters of the United States. That is a specific term that throughout history we've known what it meant.
Great point.
But then all of a sudden, the EPA started interpreting navigable water of the United States to include mud puddles and irrigation ditches and water in borrow pits along highways and riffles of water in the sand out in the desert, and pretty much anything that you could think of that might not be in a plastic bottle like this. So the EPA, taking the phrase navigable water of the United States, which 90% of the people in this room would be able to define what a navigable water was, but apparently the experts, the EPA, the people who know this, the people who are the experts that courts should defer to, could not figure out that a man-made irrigation ditch is not a navigable water of the United States. So what Chevron did is it required the courts to defer to an absurd interpretation, and this is just one example of that. What Loper-Bright did, that decision said it is up to the courts to determine what is meant by, quote, a navigable water of the United States. Now, that doesn't mean that the agencies don't weigh in. The agencies still file their briefs. They still make their arguments. They still have the U.S. attorney, the assistant U.S. attorneys appear before them and say, a navigable water of the United States ought to be interpreted this way, or it ought to be interpreted this way. But what it also does is it made it so that everyday people could also go into that court and make their presentation and their arguments as to what a navigable water of the United States meant, and go back to the history of the Clean Water Act and and why Congress never intended to include irrigation ditches, irrigation canals, borrow pits, mud puddles. The point of the Clean Water Act was for the federal government or the EPA to take jurisdiction over things like the Mississippi River, the Missouri River, the Colorado River, the Green River. But it sure wasn't to take jurisdiction over an irrigation ditch. It sure wasn't to, that was to be left to the states. Regulation of those kinds of water bodies are left to the states. Yet because of Chevron, our courts allowed the EPA to take jurisdiction over things that Congress never, ever intended. The Loper-Bright decision has correctly righted that wrong. And it doesn't mean that the agencies can't still make their arguments, can't still come in and bring in their expertise, can't still bring their expert witnesses to testify as to what these various terms should mean, but ultimately it is for the court to decide. And in light of the fact that we have had some bad decisions, such as the Chevron decision, come out, it is time for Congress to act and say it isn't up to these so-called unelected bureaucrats, because that's exactly what they are, to be making the decisions about what the law says. That is for the courts to make that determination. That's all that this bill does, is it just further clarifies the authority and the power and the jurisdiction of all of these various actors in all of these various lawsuits. With that,
Will the gentlelady yield for an affirming comment?
Sure.
I agree with you. And in fact, I think one of the problems with Chevron and our regulatory scheme is that every 4 years, regulations can swing wildly, which creates very unsettled expectations and is, I think, very difficult for the business community to plan around. And what I would suggest, if we can continue to discuss this, is that we figure out some way to establish that rules that are promulgated and affirmed by the courts cannot then just be changed every 4 years. And if there's some sort of a rebuttable presumption that a rule that's been confirmed, that's been promulgated and confirmed by the courts would remain in a new administration, I think our entire regulatory scheme would be much better off, and many, many businesses and other entities would be grateful for that.
Gentlelady yields back. Who seeks recognition? The question is on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is reported favorably to the House. The gentleman from New York requests a roll call. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey?
Yes.
Mr. Massey votes yes. Mr. Roy? Mr. Fitzgerald?
Aye.
Mr. Fitzgerald votes aye. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes aye. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott?
Aye.
Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Mr. Moskowitz. Mr. Goldman.
No.
Mr. Goldman votes no. Ms. Crockett.
No.
Ms. Crockett votes no. Mr. Klein votes aye. Mr. Moore votes aye. Mr. Issa, you're not recorded. Mr. Issa votes aye.
Clerk will report.
Mr. Chairman, there are 15 ayes and 12 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. What do we got next? Pursuant to notice, I call up H.R. 30.